Hello, I'm Vince White. I'm an employment attorney and we're answering publicly posted questions on Avo.com. Here we go. Here's our question. Can a non compete agreement in Indiana be enforced for a low wage earning employee when changing positions who is actually going to a competitor? Okay, so first and foremost, let me know no one's really going to be able to answer this question without reviewing the non compete, right? But that being said, I'm going to try to give you a general idea of some generalities in different states. I can't speak to your individual state because I'm not allowed to. But here we go. My daughter works for a transportation company making a lower wage, under $15 per hour. She is looking for a new job because she believes she is worth more money and her employer won't give her a raise. Good for her. She interviewed with another transportation company and was initially offered a position doing work that is different than her current position. The new position includes a pay increase of about 20% from what she is currently making. She called me to ask about the non compete agreement she signed. Being younger, she didn't really understand how they worked. The agreement is for 2 years with a 100-mile radius and specifically states for the same or substantially similar service. She has only been with the company for 8 months and does not have access to any confidential information. My advice was to talk with the potential employer and show them the non compete. They haven't contacted her since, and she assumes they went another direction with the job. Given that she is a low wage hourly employee who doesn't have access to sensitive information and has been with the company for under a year, should she even have mentioned the non compete? Okay, so you're picking up on a few good things here, without a doubt. A lot of states, some states, every state's different, but some states, it's really important to them that the duration, the amount of time that a non-compete flows is limited, and the geographic scope of the non-compete is limited, right? That, for instance, would be required in New York for a non-compete to be enforceable. Now, I'm not aware of too many states that require someone to earn a certain amount to be subject to a non-compete. That's not to say that's not the law somewhere. It's just to say that I haven't run across it previously. It's a good idea. We should probably get your idea in front of lawmakers because there's no reason why somebody earning $15 an hour should be, well, I mean, maybe. I guess if you're working at T-Mobile and you've got a list of cell phone clients, you shouldn't be able to go work across the street at Verizon and take their client list or something like that. But that would be dealt with proprietary information rules and contract, not necessarily not compete, right? So I see your point that there's an advantage to having people who earn lower amounts not being subject to these agreements because it limits their ability to obtain employment and to move up, right? Make lateral moves for better pay. But generally speaking, I don't think most states have gotten there yet. So speak to a local employment attorney. I would imagine a lot of local employment attorneys would be happy to say, okay, how long is your agreement? 4 pages? They might say to you, I'll read this agreement for free and I'll give you my thoughts. And it'll take me 20 minutes total and it's a freebie. Give me a nice review, right? If they're smart, they would do that. Because one, we're employment attorneys, we're supposed to help people. Two, a nice review is worth more than, right? It's worth an awful lot. So, because it lets people know that you're the kind of attorney who actually goes out of his or her way to help folks, right? So I would think they might want to help you. That being said, without actually having read the agreement and all that, I can't advise you as to the agreement. Also, because I'm not allowed to legally in the state. The last thing I'll say is, with lower earning employees, the rate of litigation, and I'm not telling your daughter to break her contract by any stretch. I'm just noting that it's unlikely, statistically speaking, that an employer would start litigation against a low-earning employee who never had access to anything that was harmful to the employer. Right? The employer still has to pay for their lawyers to sue your daughter. And they probably don't actually care. They probably have a boilerplate contract with non-compete stuff in there that applies to everybody, even though they don't actually care if your daughter goes to a competitor or not, right? So I think it's unlikely they would go after her, but that's a hunch that I have without ever having read the agreement, and that's an awful lot to make the jump to a new employer with, right? So it depends on how risk averse your daughter is. I think it'd be fine potentially there probably be no litigation that flows from her going to work for a competitor. But I don't know that. And some employers are really vindictive, and some employers are really crazy, and some employers have legitimate reasons to fight tooth and nail about any breach of a non-compete. So I can't tell you that definitively. I hope this helps. If it is helpful, consider liking and subscribing. It helps me to help more people just like you and your daughter. Good luck.